All right, everybody. We're going to drop right in there and check these suckers out. Okay. So, first off, there are a number of them. Not going to go too in deep on some of these, as the Genesis might say, in too deep, or was that Phil Collins? But I do want to touch on a number of these things that will allow us to go in deep. First, I want to mention this. The court rules that law enforcement's use of geofence warrant was a search. You got it. You got it. So let me give you this one. This is the first one. You can find this over my X feed. The Supreme Court ruled that law enforcement's use of so-called geofence warrant. Now, you see if you can figure out whether or not they went far enough to actually deride this. We're going to hop over to the SCOTUS blog to see this. But what is a geofence warrant? Can we just stop there and ask if their terminology is even on the right foot? Because it's not. A warrant is a specific announcement by the state that the state is going to search a person and search for a thing. A geofence warrant, first of all, doesn't name anybody because it's an area. So therefore, it is not. Oh, yeah, that's right. It's not a warrant. I know, it's crazy, right? Yes, indeed. They ruled that it is a search. Now, that might be insulting to some people, but it is getting them to a destination. This ruling came from mostly the left-wingers on the bench. And while they, I think, were quite egregiously in error to say that a geofence warrant was a search, without noting that it is not a real warrant, they're leading in the direction of getting people to recognize that it's not a warrant. Recognizing it as a search is correct. It is a search. The question is it a constitutional search for your civil liberties to be actually protected? Well, the court today ruled that when law enforcement officials used a so-called geofence warrant, again, red flags should go off whenever you hear that, because there's no such thing as a warrant if it's geofence. A warrant that instructed Google to provide location data for cell phone users, plural, not named, who were near a particular place during a specific time period to obtain evidence used to convict a Virginia man in a 2019 bank robbery, that they conducted a so-called search for purposes of the Fourth Amendment. So, again, some people might hear this terminology, see that they're not calling out the bogus nature of the geofence warrant term, and then see them saying that it's a search and think, oh, so they're saying it's okay, that it's somehow a search? No. They're going to be handing this back down to the lower court with instruction to tell them, hey, the police were conducting a search. Now you need to compare whether or not this process actually falls under the Fourth Amendment's strictures of what is an appropriate search. No searches shall be conducted without a warrant from a judge upon the judge's determination of just cause, reasonable suspicion to go in and search a person for a thing. So you'll see here, by a vote of 6-3, the justices sent Okello Chatri's case back to the lower court for it to consider whether, as the Fourth Amendment requires, the search was reasonable. That's not exactly it. And I have to say, Amy Howe did a bad job on this, because it's not whether or not it was reasonable. It's whether or not it was a search that a judge determined specifically to be a reasonable, and I don't like that term, a reasonable search of an individual. That's the distinction about geofencing. And very clearly, if you read this ruling, as I did today, the Supreme Court majority, 6-3, clearly does not think that this falls under what is required by the Fourth Amendment. Writing for the majority, Justice Elena Kagan emphasized that, quote, get this, an individual has a reasonable expectation of privacy in records about his cell phone location, and police intrude on that constitutionally protected interest when they demand the information, even though for only a limited time, and from a third-party tech company. I'm going to stress this and keep it brief because this is the major lesson of the whole thing. Again, you could replace the names, you could replace the location, you could replace the circumstances. None of that is really relevant to the process of what is called a geofence warrant. This is just one of many cases that could have been brought up to oppose a geofence warrant. Now, Justice Samuel Alito, in a dissenting opinion, joined in part by Clarence Thomas. Listen to this. This is ends justify the means argumentation. When you read their whole opinion, it's just devastating to think that they have any respect for the Fourth Amendment. And these are so-called conservatives. In a dissenting opinion, Sam Alito, joined in part by Clarence Thomas and Amy Coney Barrett, contended that the majority's opinion, quote, will send seismic waves through our Fourth Amendment doctrine, but would ultimately not have any effect on Chaudhry's case. That's not relevant. That's not the point. The point is whether or not the Fourth Amendment was upheld, and it was not. And if it has seismic waves that go through the Fourth Amendment doctrine, your implication is, of course, that this could have an effect on police pulling over a person and searching a person without knowing the person's identity and without a judge's warrant. Well, guess what? They're not supposed to do that either. It's not the police on hand who can say, well, I had reasonable suspicion. No, the Fourth Amendment clearly states a judge issues a warrant upon the judge's determination of reasonable suspicion. It's supposed to be a longer process. It's supposed to be deliberative, and it's supposed to be open to the public. The issue at the center of Chaudhry v. United States arose after a man armed with a gun entered a federal credit union outside Richmond, Virginia, and gave the teller a note demanding money. He made off with nearly $200,000. Must have been an IRS agent. But law enforcement officials did not have any leads until they served Google with a geofence warrant. Again, there isn't such a thing. This is like administrative warrant. We can't allow these people to get away with this stuff. They put together these verbal constructions that destruct your rights. You can't allow this to happen. You've got to stop this, whether it's for yourself or somebody else in a future generation. We've got to stand up to this stuff. So that's that story. That's a big one. Again, you can tell I almost went to school for law because I'm interested in the constitutional law stuff, even though I'm an anarchist. So, second piece on the SCOTUS. In the news notes, the Supreme Court today ruled that Trump did not follow proper procedure when firing Fed board member Lisa Cook. This ruling solely is based on procedure, not due process or punishment without trial. The Supreme Court majority noted that they need not go into the other items to rule that this move was unlawful based on the statute for firing because Trump did not give her due notice within the statutory requirement of her firing. So there's more on this one. There are a couple different stories on this one. You're probably familiar. They tried to go after Lisa Cook, and I've got video to show you about that. Of course, this is a Fed Reserve governor. And Donald Trump wanted to get rid of her because she didn't want to lower interest rates. In fact, let me show you a little bit of this information coming right up here. All right. So let me give you some of this stuff right here. This ought to be it, I think. Yes, here it is. Okay. Now, this one needed amplification. Let me give you the basics. This is from MSN.
I think we have Eamon Javers from Washington who's been going through this opinion and this decision. Eamon, what can you tell us?
Yeah, Sarah, first of all, we can say that the vote here is 5-4. So that's a break from the Supreme Court's recent run of 6-3 decisions. So that's an interesting one. We'll have to look at the makeup of that 5-4 decision. And one of the things that I'm looking at in this decision on page 17 of the ruling is this issue of whether or not the Supreme Court was going to decide whether this was for cause or whether this was going to be about Lisa Cook and whether she was allowed enough formal notice and process in this effort by President Trump to fire her from the Federal Reserve Board. And what the Supreme Court has said here is no matter the precise definition of cause or the scope of our review of any such determination, The president failed to afford Cook the procedural protections to which she was entitled by statute. Without such protections, she could not properly dispute the charges the president laid against her. We thus need not address Cook's constitutional due process agreement, for the statute alone makes it unlikely that the government will prevail on appeal as to the validity of the procedures used to fire Cook. So
Okay, so what that essentially is telling me, and you let me know if you think my instincts are correct here. So if you look at this ruling, this one, I just scanned this one for a little less time, but the gist of this is, as he noted, there is no due process question here because it didn't reach that point. They didn't have to argue whether or not she was being punished without trial, which would have run contrary to the 5th, 6th, and 8th and 14th Amendments, because they already said there was a wrongdoing by the government regarding the process of her firing. So they're not even going to approach whether or not she has constitutional grounds to say, you fired me, you punished me by taking away my job, and I didn't do anything wrong. Now, on a larger constitutional basis, as far as the separation of powers goes, within the executive branch, as unconstitutional as the Federal Reserve is and as so-called autonomous as it is, the Federal Reserve Board, under the creation of the Federal Reserve a century plus ago, is that the president can appoint the board governors and can appoint the Fed chairman and can remove them, and should be able to remove them according to the way the executive branch works if they are within the executive branch, which they are. Even though they say they're semi-autonomous, the actual Federal Reserve was created by Congress. The operation of it is an executive branch function, and it could come down to it where the president says, I'm not going to appoint anybody else to the Federal Reserve. Once they all die, nobody else is going to be on there, right? He could do that. Then, as far as the separation of powers goes, and as far as the statutory level of things goes, then it would be up to Congress to say, are the actions by the president, who swears an oath to protect and defend the Constitution, are those actions consistent with what we see as constitutional actions? So then that would depend on the composition of the Congress to say, we think that the statute that was passed in the early 1900s that created the Federal Reserve is constitutional, even though it's not. And therefore, Trump has a requirement to put these board members together and to elect a chairman of the federal board, right? But I'm going to put aside whether or not it is constitutional or not. The president can still disregard them. So again, the president can say, just like with any other statute, sure, you've passed a statute, I'm not going to enforce that statute. Then the next step would be Congress to say, does that reach a level of an impeachable offense for us to get rid of that guy, right? Now, personally, very clearly, I see the Federal Reserve as patently unconstitutional, a skirting of the requirement that the Treasury coin the money. And I don't even like any governmental fiat currency power in any way whatsoever, because they always inflate the currency supply, right? And destroy the buying power of the currency. Whether it's ancient Rome or the United States, it doesn't matter if it's the Federal Reserve or the Treasury, they would always do it, whatever entity it is, because it facilitates government expansion and paying off friends for political purposes to get votes and gain favor with people. That's always the way it goes. It always has to expand and the money supply gets diluted. But as far as this decision goes, this is very interesting because now it's up to Trump. What is going to happen? Is she going to get her job back? Or is Trump going to say, no, you are gone? If this continues, the court can't compel him. They have no executive power. They can only render an opinion. So then it leaves it up to the Congress to say, hey, there's been a Supreme Court ruling here. You've been, in the ruling, they say that you didn't do the right thing. So are you going to be paying her salary? Is she going to go back on the Fed board or not? And then it's up to Congress. If Trump continues to disregard and continues to do something that the majority in Congress feel is unconstitutional, then it's up to them to impeach him. But for God's sake, they haven't impeached him on all the other unconstitutional stuff he's done. If he actually were to conform on this and say, well, yeah, I'll conform with the Supreme Court ruling, I don't think they would care one way or the other. I don't think they would care if he didn't conform or if he did conform. because they clearly don't care about the United States supplying weapons for genocide. Now, let me go over to this one. This is another big one. There's a rebuff of Alan Dershowitz here. So just to give you this, the Supreme Court declines to hear Alan Dershowitz's $300 million CNN defamation case. The Supreme Court declined to hear Dershowitz's bid to revive his $300 million defamation lawsuit against CNN, leaving intact lower court rulings in the network's favor. The case stems from CNN's coverage of remarks made by former Harvard law professor while serving on Trump's legal team during Trump's first impeachment trial in 2020. Dershowitz claimed the network selectively edited his comments and falsely portrayed his constitutional argument. The federal judge first dismissed Dershowitz's claims in 2023, finding he had produced no evidence that CNN acted with actual malice required for public figures to prevail in defamation cases. Justices Thomas and Gorsuch, both of whom have previously questioned whether New York Times v. Sullivan should remain the governing standard for defamation suits involving public officials and public figures, and that goes back to 1964, dissented from the court's refusal to hear the case. In his filing, Dershowitz had urged the court to reconsider the decades-old precedent, arguing that media organizations have become nearly untouchable until their protections under the ruling's protections, and wrote that the ruling has, quote, morphed into an impregnable fortress that protects media irresponsibility when denying public figures any remedy for egregious misrepresentations. Now, this all stems from whether or not there was actual malice, right? And that really is that's a place for the jury to hear, in my opinion. So that's just neither here nor there on that. And finally, I want to give you this one. The FTC commissioner, and I was listening to Owen Schroyer today, and Owen was like, how can the Supreme Court find that Trump can fire the FTC commissioner, but can't fire the member of the Fed board? Well, the reason is that there's a difference in the process for the firing of the Federal Trade Commissioner and the process of firing the board member. And the process of firing the Federal Trade Commissioner is, of course, for cause. The Supreme Court on Monday gave President Trump sweeping new authority over approximately 24 multi-member agencies that Congress intended to be independent. By a vote of 6-3, the justices struck down a federal law that bars the president from firing members of the Federal Trade Commission except in cases of inefficiency, neglect of duty, or malfeasance in office. That law, a majority of the justices ruled, violates the constitutional separation of powers between the three branches of the government. And again, I would say the same thing regarding the Supreme Court. Regarding the Federal Reserve. I think that if Trump is in charge in the executive branch, he should be able to fire members of the Federal Reserve regardless of what the statute says. But then again, it just depends on whether or not Congress says, hey, we put something in that statute, and Trump can say, well, I'm the executive branch and I'll do what I want. Then it's up to them to decide whether they want to boot him. Now, I want to give you this one. And this is the new approach from Trump that we mentioned a little bit earlier. It's the Trump weekend parade. Like, those shoe stores, Parade of Shoes. Didn't they have Parade of Shoes, Parade of something? I don't know what it was. But Trump's new approach, everybody, is that he's the great hero in opposing communism. So let's get into that. I want to get your opinions to see whether or not you've seen this as well. Here is the headline as I scroll down. Thank you, Russians. Trump's midterm election tactic, rhetoric about Trump v. communism in America. They come into America today. Yes, Neil, that's right. So let's go to a little theme for this one and hit something from the Psychedelic Furs.